Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, in continuation with our previous lecture on the President rule, we are going to start from the point where we left in our previous lecture. We discussed about the recommendation of various committee to the abuse and misuse of imposition of President rule under Article 356. This is the point where we left. We would be continuing and would be discussing more on the recommendations of the various committee to the abuse and misuse of imposition of President rule under Article 356, as well as we are going to discuss Sarkaria Commission's recommendations, as well as we are going to know how Indian judiciary has interpreted the provision on Article 356, and for this we have again with us in our studios Dr. Rakesh Kumar. Dr. Rakesh Kumar is Assistant Professor in University School of Law and Legal Studies, Guru Gobind Singh IP University. So without wasting any time, I would like to welcome our guest Dr. Rakesh Kumar. Dr. Kumar, welcome to the EduSet lecture.
Thank you, Gitika. Good morning, listeners. In my previous lectures on the President rules, I have given you the constitutional provisions regarding the impositions of President rule under Article 356 of the Constitutions. And what I stated under Article 356 is that if the President, on the receipt of the report from the Governor or otherwise is satisfied that situation has been created in which the government of state cannot be carried on in accordance with the provisions of the constitutions, then he may issue a proclamations under Article 356 of the constitutions, and by that proclamations he may take over the government of the state, or he may specify that the legislative functions of the state may be carried out under the authority of the parliament, or he may appoint any other person. So normally what is happening under Article 356 is that when the elected government is dismissed, then that case here the governor is being given the administrative control over the functioning of the state executive powers, and all the law making is being done on the behalf by the governors or by the under the control of the parliament itself. So because the Article 356 is the bone of contentions between the center and state, and it has created tensions with respect to the working of the federal scheme of the constitutions. And this is the one of the provisions where the Ambedkar has stated during the framing the constitution that it will remain a dead letter in the constitutions, and the occasions of the invoking Article 356 will not arise. But this is the one of the provisions of the constitution which was subject to the constant misuse or abuse by the central executives, and the times and again the protest or the apprehension is being raised by the various political party, including the regional political party, where they have strongly protested regarding the misuse of power by the governor, where they have recommended the president regarding the impositions of President rule under Article 356 of the constitutions. And here this issue was subject to the various review by the various committee which was constituted by the government of India time to time to suggest the measure regarding what needs to be done regarding the providing the safeguards regarding the alleged misuse of power by the president by invoking Article 356 and dismissing the democratically elected state government. And with respect to this, in the previous lectures I have already given you the brief idea as to how the Administrative Reform Committee, which was constituted in 1968, has suggested regarding the impositions of President rule, and what they have stated in crux is that here the governor should exercise his own judgment with respect to the impositions of President rule under Article 356 of the Constitution. So this was the very important recommendation which was given by the Administrative Reform Commissions in 1968 to somehow ensure or to check the misuse of power by the president under Article 356 of the Constitution. But this recommendation was not accepted by the government. Then subsequently again the Bhagwan Sahay committee was being constituted by the central government under the chairmanship of the then governor of the J&K, Bhagwan Sahay, and here this Bhagwan Sahay committee has also given the various recommendations regarding the impositions of the President rule, and the most important recommendation was that it is the responsibility of the governor to see that the administration of the state does not break down due to the political instability, and he must send a regular report about the political situation in the state, because under the conventions which have developed in this regard is that here the governor is required to send the fortnightly report to the president regarding the prevailing law and order situation in the state, as well as the important executives and legislative measures which has been taken by the state government. So here what is stated that as far the impositions of president rule is concerned, here it has to be ensured by the governor that the prevailing law and order situation should not lead to the complete breakdown of the law and order situations, and he should continue to send the regular report to the president. And the other recommendation about the governor should also report to president about any serious internal disturbance or external aggression the state concerns, and about the action taken under Article 356 of the Constitution. But as far the approach which was suggested by the Bhagwan Sahai committee was that before recommending the president regarding the impositions of president rule, here the governor should exercise the best judgment, and the best judgment should be the guiding principle so far as the impositions of Article 356 is concerned. And subsequent to that, the Raj Manar committee was being constituted by the DMK government, and the P.V. Rajmanar, he was he was the former Chief Justice of the Madras High Court, and here this committee has given the far-reaching recommendation regarding the Article 356 of the Constitution, and this committee has suggested that outrightly they have suggested regarding the deletions of or repeal of the Article 356 and 357 of the Constitution, and this committee has also suggested that the necessary safeguard has to be provided in the interest of the state against any arbitrary or unilateral use of the power by the central government. And as far the role of the governor with respect to the recommending to the president concerns, here this committee emphasized that the governor should not consider himself as agent of the center, but he must play his constitutional role as assigned under the Indian constitutions. And apart from this Raj Manar committee has also suggested that the governor, before recommending the president rule, should explore all the possible avenue to him to secure a ministry which would command the confidence of the legislatures, and the only other contingency which would justify the impositions of president rule is the complete breakdown of the law and order situation in the state. So in crux what was suggested by the Raj Manar committee was that if it is a case of the complete breakdown of the law and order machinery in the state, then only in such case here the governor should recommend the president regarding the impositions of president rule under Article 356 of the Constitution. But as far the role of the governor is concerned, here what the Raj Manar committee suggested that here the governor should explore all the possibility of forming the alternative government if the majority government has been reduced to minority either because of defections, or if the coalition government is being reduced to minority because of the withdrawal of the support by one of the partners. So before it is only after exploring all the possibility, and where it is not possible to form the alternative government, then only in such case the governor may be justified to request the president regarding the impositions of president rule under Article 356 of the Constitution. And as far whether the state government is enjoying the confidence of legislatures is not with respect to this, here what the Raj Manar committee has suggested that the only forum which could decide the questions whether the ministry could continue office is the legislative assembly. So in crux what he wanted to say that if the governor, because of the withdrawal of the support or because of defections, if they are having any kind of apprehensions that the state government is no more enjoying the confidence of the majority of the members of a state legislature, then that case, instead of deciding this issue by sitting in the drawing room, they should ask the chief ministers to prove the majority on the floor of the house. And apart from this committee has also suggested that before sending his recommendations to the president, here the governor should refer the report to the legislative assembly within a specified period to know about the assembly view. So what he was saying that actually he was that before imposition of president rule, you should give the chance to the state government to explain the positions, and it is only after ascertaining the view of the state legislatures and that view which was submitted by the state legislature should also become the integral component of the impositions of President rule under Article 356 of the Constitution. And as far the other recommendation is concerned, here any contraventions of or failure to implement the directions issued by the union government to state under no circumstances be made a ground for impositions of President rule. So, what in crux he wanted to convey that the provisions regarding Article 365, where the union executive is empowered or entitled to give the necessary directions to state government regarding how the state executive function has to be carried out. Here, if any such direction is being issued by the union executive to state government, and if the state government is not willing or they are not in positions to implement those directions, then that case here Article 365 should not be used as a pretext for impositions of President rule under Article 356 of the Constitution. So, obviously, whatever the recommendation which was given by the Rajmanar committee, it was having the far reaching effect, and some of the measures regarding the repeal or deletions of Article 356 and 357 is concerned. Definitely these kind of recommendations cannot be accepted, because we are living in the multi-plurals and multicultural society, and we are having the all kind of diversity. It is the cultural diversity, religious diversity, linguistic diversity, and in these diverse situations here maintaining the unity and integrity of the nation is the para importance. So, if this kind of provisions will be deleted, then that case the center will not have the any instrument by which they can control the deviant state government which are not following the directions of the union executives, as well as they are not implementing the directions which was issued by the union executive. So, for maintaining unity and integrity of the nations, definitely we needs to have the provisions like Article 356 of the Constitution, but as far the apprehensions of the misuse or abuse of power is concerned, necessary we also feel that the some kind of the necessary safeguard has to be introduced. And as far this Rajmanar committee recommendation is concerned, definitely it is very important as far the autonomous state is concerned, and it is also something which is going to strengthen the federal fabric of the Constitution. But however, the recommendation which was given by the Rajmanar committee was rejected by the union government. So, after the Rajmanar committee, this issue was again referred to the Sarkaria commissions. Here the Justice R.S. Sarkaria, which was constituted to examine the central state relations in March 1983, and it was headed by the Justice R.S. Sarkaria, and it also having the members like the B. Shivramans as well as S.R. Sen. And as far this committee is concerned, here this committee has submitted report in year 1988, and before submitting the reports, here the Sarkaria commissions has also invited the response from all the stakeholders, that is the state government. They have also invited the suggestions from the academicians, they have also invited suggestions from the legal experts, and apart from this here the Sarkaria commissions has also analyzed the report which was submitted previously, and as well the judicial trend which was being followed with respect to the impositions of President rule. And if you see the kind of suggestions which was given by the various state government is concerned, here the some of the state government has recommended for the repeal of the Article 356, but definitely these recommendations cannot be accepted because of the racialism, linguistic or the communalism or casteism factors, because it is something which is going to strike at the very unity and integrity of the nations. But as far the provisions regarding impositions of President rule concerns, here some of the state has suggested that the Article 356 should be resorted only when in the case of the serious breakdown of the law and order, paralyzing the state administrations, where the state government lacks the will and capability to meet the situations. So, it is only in the case of the complete failure on the part of the state government to maintain the law and order situations, then that could be one of the ground for impositions of President rule. And here some of the state has also suggested that before invoking the Article 356 of the Constitution, here the matter is to be referred to the interstate councils or standing committee of the interstate council, and it is only with the prior approval of the state interstate council or is standing committee, here the president can invoke Article 356 to dismiss the democratically elected government. Apart from this, some of the state has also suggested that here before invoking the Article 356, here the president should also follow the principle of natural justice, and here the principle of natural justice is concerned. Here before sending the report to the president, a governor should obtain the comment of the respective state government, and apart from the accepting the comment, here he should also convey the reason for the action contemplated under Article 356 of the Constitution, and the governor should also take into consideration the clarifications of the state government which is being provided with respect to the prevailing law and order situations under which they are in the favor of they are in the opinion of the invocations of president rule under Article 356 of the Constitution. So here the in crux almost all the state government was in the view that there is need for the impositions of the serious restrictions with respect to the impositions of president rule under Article 356 of the Constitution, because we are living also in the pluralistic democracy, and in pluralistic democracy it is possible that the center and state may be ruled by the different political party. So mere fact that the state government is being ruled by the other political party should not be considered a ground for dismissing the democratically elected state government. So as far the Sarkaria Commission recommendation is concerned, here the Sarkaria Commission has recommended that as far the invocations of Article 356 is concerned, it has to be used only in the very rare case and where it becomes unavoidable to restore the breakdown the constitutional machinery of the state. And as far the invocations of Article 356 is concerned, here the committee has suggested that Article 356 should be used very sparingly in extreme cases as measure of last resort when all the available alternatives fail to prevent or rectify the breakdown of the constitutional machinery of the state. So what they wanted to convey that it is only in the rarest of the rare case where there is a complete breakdown of the constitutional machinery of the state, then only in such case here the president rule can be imposed under Article 356 of the Constitution. The second important recommendations of Sarkaria Commission was that a specific warning should be issued to the such a state in a specific terms that it is not carrying on the government in accordance with the provisions of the constitutions. However, as far the warning provisions concerns, here this the requirement of the issuing the specific warning may be dispensed where it is not possible to take where it is not where it is required that the immediate action has to be taken with respect to the dismissing the state government and imposition of president rule, otherwise it may lead to the disastrous consequence. The third important recommendation was that when external aggressions or internal disturbance has paralyzed the state administrations, creating a situations drifting towards a potential breakdown of the constitutional machinery of the state, then all the alternative courts available to the union for discharging its paramount responsibility under Article 355 should be exhausted to contain the situations, because here the Article 355 imposes a specific duty on the state to protect the state against the external aggressions or internal disturbance, and in performance of these specific duty which is being assigned to the state government under Article 355 of the Constitution concerns, here it could be used as one of the justifications for impositions of president rule under Article 356 of the Constitution. The other recommendations of Sarkaria Commission was that in case of the political breakdown, here the governor should explore all the possibility of having the government enjoying a majority support in the assembly, and if it is not possible for such government to be installed, and if fresh elections can be held without unavoidable delay. So he should ask the outgoing ministry if there is one to continue as a caretaker government. So what they wanted to convey that the first to explore the possibility of installing the alternative government. If that possibility is completely ruled out because none of the political party are willing to come on a single platform to provide a stable and viable government, and there is no possibility of the any such alliance to come together to provide the government, then that case, and it becomes unavoidable that the any such situation do not exist, then that case here he should immediately order for the fresh elections. And if the governor has recommended for the impositions of president rule or so what the Sarkaria Commission wanted to convey, that instead of the imposition of president rule, here they should ask the president, so president in turn request the election commissions to conduct the fresh elections, and the outgoing chief minister should be allowed to continue as a caretaker government. However, he has also issued a advisory caution that suppose if there is a charges of maladministrations or the corruptions against the chief ministers, or if the state government is inherently incapable of running the affairs of the state, then that case here the governor should not allow such persons to continue as a caretaker chief ministers, and instead of that he should recommend the president regarding the impositions of president rule under article 356 of the constitution. So, and the other recommendation of Sarkari Commission was that before proclamations should be placed, proclamations to be issued with respect to state, here it has to be placed before each house of parliament at the earliest, and in any case before the expiry of 2-month period contemplated under clause 3 to article 356. So, it means if the proclamation is being issued under article 356 of the constitution, then it has to be placed before the both house of parliament at the earliest moment. So, parliament can scrutinize or parliament can review the desirability of the impositions of president rule under article 356 of the constitution. And as far as the power of the governor to dissolve the state assembly is concerned under article 174 clause 2 is concerned, here what the Sarkaria Commission suggested, that the governor, the president should not dissolve the state assembly before the approval of the parliament, before the approval of the proclamations by the each house of parliament. So, it is only after the approval of the proclamations by the both house of parliament, here the president, the governor can think of the dissolutions of the state assembly. As far because what is being prescribed by the article 356 clause 1, that it is on the receipt of the report of the governor or otherwise, if the president reached to the conclusion the government state cannot be carried on in accordance with the provision of the constitution. So, what the Sarkaria Commission has suggested with respect to the report which may be submitted by the governor regarding the imposition of president rule concerns, here the Sarkaria Commission has suggested that all the material facts and ground on which the article 356 clause 1 is to be invoked should be made an integral part of the proclamations under article 356 of the constitution. And as far the report of the governor to president concerns, here the report which was submitted by the governor should be placed before the both house of parliament, and the report of the governor regarding the impositions of president rule should be a speaking order. So, speaking order here means that the governor must clearly delineates all the material facts and circumstances under which he has reached to the conclusion that the government state cannot be carried on in accordance with the provisions of the constitutions, and accordingly he is requesting the president that in such case, or where the case of the political instability or the case of the constitutional breakdown or the case of the physical breakdown, then that case he should recommend the president regarding the impositions of president rule. So, as far the power of the governor is concerned, here the president rule in the state should be proclaimed on the basis of the governor report in the normal circumstances. So, here the Sarkaria Commission has not altogether negated the requirement of the governor to send the report to the. So, primarily it is the governor reports which will be considered criteria for impositions of president rule under article 356 of the constitution. So, it is obvious that Sarkaria Commission suggestions are useful to check upon the misuse of the provisions relating to the president rule, and it is also something which will promote the constitutional structures of the cooperative federalism, and it will also somehow strengthen the federal institutions. So, it will be also very helpful in promoting the healthy center state relations and the federal setup, but because the political will on the part of the ruling party, the center, here all the recommendations are not being accepted by the president. It is only after the Bombay judgment some of the recommendations which was given by the Sarkaria Commission has been made a part of the judgment itself, and now it has become the binding as well the guiding force for impositions of precedent rule under India. So, as far the judicial interpretations to the precedent rule is concerned, here I am before going to this place here after the Sarkaria Commissions, I would also like to draw your attentions regarding the recommendation which was given by the Venkat Chalaya Committee in year 2002. Here the Venkat Chalaya Committee was being constituted by the BJP government to examine the working of the constitutions, and here the Venkat Chalaya Committee has given the very important recommendations regarding the impositions of precedent rule. And what the in crux the Venkat Chalaya Committee has also somehow upheld the various recommendations which was given by the Justice Sarkaria. So, as far the Venkat Chalaya Commission is concerned, here this committee has also formed the various subcommittee, and the Justice Sarkaria was one of the important members regarding the emergency provisions, and as well as the justice. One more judge was also being has given the presentations regarding the precedent rule. So, what the Venkat Chalaya Committee has suggested that in the spirit of the frame of the constitutions, that Article 356 must be used sparingly and only as a remedy of the last resort after exhausting all the possible avenue under Article 256, 257 as well as Article 355 of the Constitution. So, Venkat Chalaya Committee has also taken cognizance of the constant misuse of power by the union government regarding the dismissing the state government and invocations of the precedent rule. So, they have suggested that it should be used sparingly and only in the rare case. And the second important recommendation of Venkat Chalaya Committee was that before issuing proclamations under Article 356, the concerned state should be given opportunity to explain its positions and redress the situations, unless the situation is such that following of the above course would not be in the interest of the security state or defense of the country or for any other reasons necessitating the urgent actions. So, what the Venkat Chalaya Committee suggested that you also give the warning to the state government and you ask them to rectify the situations or improve the prevailing law and order situations. It is only such case where it is not possible because it is something which is going to affect the security state or defense of India. Then that case this requirement of giving the specific warning or cautions or advice to the state government may be dispensed. As far the case of the political instability, here the Venkat Chalaya Committee has suggested that the question whether the Council of Ministers has lost the confidence of the State Assembly or not, it should be decided only on the floor of the House and not anywhere else. So, Venkat Chalaya Committee was also viewed that in case of the political instability, because of withdrawal of the support or because of defections, or then that case here the governor should ask the chief ministers to prove their majority in the shortest possible time, and it is only in such cases where the state chief minister has failed to prove their majority on the floor of the House, then that case here the governor will be justified to recommending the president regarding the imposition of precedent rule. But as far the requirement of the proving the majority on the floor of the assembly is concerned, here this requirement may also be dispensed with under the certain situations like the case of where the governor has seized with all the possible avenue of the formations of the alternative government enjoying the majority support in the state legislatures. And the other recommendation was the governor cannot be if the alternative government cannot be formed and if the fresh election is to be held without delay, then governor should ask the outgoing ministry to continue as a caretaker government, and the governor should not be allowed to dismiss the ministry so long as it enjoy the confidence of the House, and it is only where the chief minister refused to resign after his ministry is defeated on the motion of no confidence, then governor can dismiss the state government and they can impose the precedent rule. So, in crux here this Venkat Chalaya Committee has also somehow approved the suggestions which was given by the Justice Sarkaria. And after giving the view of the various committee which was constituted by the government regarding under what circumstances the president rule can be imposed, and what are the other precautionary safeguard which has to be observed on the part of the governor, and what are the safeguard which has to be, what are the cautions which has to be exercised by the union government. Now I am coming to the how the Indian judiciary has interpreted the power of president to impose the president rule under article 356 of the constitution. As per the approach of judiciary is concerned, it can broadly be divided into three parts. In first part we will take up the approach which was being adopted by the different high court regarding the scope of judicial review regarding the imposition of president rule under article 356 is concerned before state of Rajasthan case. So before state of Rajasthan case, we will have the one set of approach which was being adopted by the various high court regarding the dismissals of various ministry by the president on the report of the governor. Then the state of Rajasthan versus Union of India case itself is the very important judgment of the Supreme Court, where after emergency here the Janata Party which were ruling in the at the center has dismissed all the Congress ruled 9 states after the massive defeat of the Congress party in the Lok Sabha elections after emergency. Then after the, so other set was started from the state of Rajasthan onwards, and then we will come to the Bombay judgment and how the Bombay judgment is being implemented, or how the Bombay judgment is being observed by the union executives before invoking the article 356 of the constitution. So as far as the scope of judicial review before state of Rajasthan case is concerned, here this issue has directly arisen before the Haryana High Court, Chandigarh High Court in Rao Birendra Singh versus Union of India case, and here the issue was as to what are the scope of judicial review with respect to the impositions of president rule under article 356 of the constitution. So here in this case the High Court has laid down the three specific ground regarding the delineating the scope of judicial review. The first ground which was stated by the High Court was that the court cannot go into the validity of the proclamations because the president is not amenable to jurisdictions of the court in view of the article 368 clause 1 of the constitution, because the article 361 clause 1 of the constitution, here the exercise of power or exercise of subjective satisfactions by the president cannot be subject to judicial review. The second important recommendation was that the reconsideration of the proclamations being specifically vested by the constitution of the parliament, therefore it has excluded the court jurisdiction, because what is being prescribed by the article 356 clause 3, that if any proclamation is being issued by the president under article 356 of the constitution, then that case such proclamation has to be laid before the both house of the parliament within the period of 2 months from the date of proclamation of president rule. And if the both house of parliament has decided to approve the proclamations which was issued by the president under article 356 of the constitution, then the president will have the power to continue with the proclamations for the period of 6 months from the date of issuance of proclamations. And it is only after the expiry of the 6 months, if the president still thinks that there is need for the continuations of proclamations in that stage, then that case they again have to go to, before the both house of parliament, and they have to seek the approval of the parliament for the continuation of proclamation. So what the High Court has stated in that case, here the constitution itself has provided for review of the proclamations which may be issued by the union executives under article 356 of the constitution concerns. It has to be only by the parliament, not by the judiciary. And the other the third important point which was stated by the Haryana High Court in this case is that the court however considered the merit of the presidential proclamations and held that there was ample and sufficient material in the report of the governor that administration state has been paralyzed and there was no real functioning of the state government. So this was the crux of the recommendations which was given by the Chandigarh High Court regarding the impositions of president rule in state of Haryana in year 1968, and this here the president rule was imposed on the ground of the defections in the ruling party. Then this issue was again considered by the Andhra Pradesh High Court in A. Sri Malu case in 1974, and here the single judge of the Andhra Pradesh High Court, which was manned by the Justice Chinnappa Reddy, he stated that the presidential proclamation issue under Article 356 is not susceptible to judicial review, because the issue of the president's satisfactions under Article 356 is basically a political issue. The Constitution does not enumerate the situations where the president rule can be imposed, and there are no satisfactory criteria for judicial determinations of what are relevant considerations for invoking the power under Article 356 of the Constitution. So, consequently, the question is intrinsically politically and beyond the reach of the court. So, here this case also the court stated that since it is a political issue, so it is something which has to be decided by the executives, or it has to be reviewed by the parliament. Here the judiciary cannot interfere with respect to the exercise of power by the president under Article 356 of the Constitution. Then again this issue was being considered by the Vijay Nanda versus President of India case in 1974, where Odisha the Nandini Satpathy government was being reduced to minority because of defections. Then this case also the Supreme Court, the High Court, Odisha High Court has expressed the same view regarding the scope of judicial review by saying that the whole source of informations as contemplated by expressions otherwise in Article 356 is something where the court cannot interfere or intervene with the respect to the exercise of power by the president. And second important recommendation was that if the president has reached to the conclusion that the government state cannot be carried on in accordance with the provision of the constitutions, then it provide for the subjective nature of satisfactions by the president, and it cannot be subject to the objective review by the judiciary. The third important thing which was stated by the Odisha High Court is that the provisions of Article 74 clause 2 as well as Article 361 clause 1, which preclude the court from testing the ground of satisfactions, on the basis of which he has reached to the conclusion regarding the impositions of president rule or otherwise. And the fourth important recommendation was the provisions for parliamentary approval for continuations of proclamations beyond 2 months from date of his proclamations. And so here what in crux the Odisha High Court stated that as far the power president under Article 352, 356 or 360 regarding the imposition of financial emergencies concerns, here it is not subject to judicial review, it is not justiciable, and judiciary has to keep their hands off. And after the approach which you have seen with respect to the impositions of president rule in the various high court, now I am coming to the specific case, that is state of Rajasthan versus Union of India. This case was decided by the year 1977 by the 7 bench of the Supreme Court, and this case has arisen with respect to very peculiar situations. What happened in this case is that after 1975, after the lifting of emergency, the general elections for Lok Sabha was held in the year 1977, and in that elections the Congress party was suffered a rude jolt in the hands of the electorate, and the Janata Party headed by the Morarji Desai came into power with a thumping majority, and they have secured almost 351 seats of the total seats in the Lok Sabha. So after the general Lok Sabha elections, here the Morarji Desai became the Prime Ministers, and Chaudhary Charan Singh was the Home Minister at that point of time. So what the Chaudhary Charan Singh did in this case is that he issued advisory to all the Congress ruled state government that they have to request the governor regarding dissolutions of the state assembly in view of the complete routs of the Congress party in the general elections. Apart from this, here the law minister has also issued a broadcast with the All India Radio, where he has stated that the government in the Congress state had forfeited the confidence of the electorate, and their continuance in the office was undemocratic. So because of this kind of the directives which was issued by the then Home Minister Chaudhary Charan Singh to the Congress ruled 9 state government, here the state of Rajasthan has approached the Supreme Court and they have challenged the directives which was issued by the state government, which was issued by the Union Home Minister to the which was issued by the Union Home Minister to this Congress ruled state, and they have challenged under Article 131 of the Constitution. And Article 131 of the Constitution provide for the impositions or provide for the original jurisdictions with respect to the interstate disputes. So, here in this case all the 6 states, the state of Rajasthan, Madhya Pradesh, Punjab, Bihar, Himachal Pradesh, Orissa filed writ petitions in the Supreme Court, and here the main submission of the petitioner was that the Home Minister letters and the radio broadcast of the law ministers continue a clear threat of the dissolution of the assembly and disclose a ground which were prima facie outside the purview of the Article 356 of the Constitution. Here when this case came before the Supreme Court, then the Supreme Court has unanimously they have unanimously dismissed the petition which was filed by the various Congress ruled state, and the court held that it could not interfere with the central exercise of power under Article 356 of the Constitution merely on the ground that the action of the central government embraced political and executive policy and expediency unless some constitutional provisions was being infringed. So, and there the court has also stated that Article 74 clause 2 disable the court from inquiring into the existence of the nature and the content of the ministerial advice which was given to the president. So, what the court stated that what the advice which was given by the governor to the president, or what the advice which was given by the council minister to the president, then such advice are not subject to the subject to judicial review because of the specific provisions that is being provided by the Article 74 clause 2 as well as Article 361 clause 1 of the Constitution. So, and the other thing is that here the court stated that the clause 5 of Article 356 made it impossible for the court to question the presidential satisfactions with respect to the impositions of president rule. So, here the presidential satisfactions cannot be subject matter of the judicial scrutiny under the broad premises of judicial review. But here in this case also the court had somehow stated the view that if any such president rule is being issued by the president under Article 356 of the Constitution, then it will be subject to the limited judicial review on the ground that the exercise of power by the president is completely unjustifiable, or it is suffering from the vice that it amount to the patent misuse of the power by the president regarding the invocations of president rule under Article 356 of the Constitution. So, apart from this, here but as far if you see the observations which was expressed by the Supreme Court, particularly by the Justice Bhagwati and A.C. Gupta is concerned, here what he stated that merely because the questions has political complexions, that by itself is no ground why the court should shrink from performing its duty under the Constitutions if it raises an issue of the constitutional determinations. Merely because the question has political color, the court cannot fold its hand in disputes and declares judicial handoff. So, as far the president's satisfaction is concerned, here what the court stated that the satisfaction of president is subjective one and it cannot be tested by reference to any objective test. So, there may be wide range of the situations which may arise and their political implications and consequences may have to be evaluated in order to decide whether situation is such that the government state cannot be carried on in accordance with the provisions of the Constitution. But as far the power president is concerned, here the Supreme Court has also stated that, but one thing is certain that if the satisfactions on the basis of which the president had decided to issue the president rule is a mala fide, or if it is based on the wholly extraneous or irrelevant ground, then court will have the limited jurisdictions to examine the basis for the impositions of president rule under Article 356 of the Constitution. So, here this narrow minimal area in which the exercise of power under Article 356 clause 1 is subject to judicial review, and apart from it, it cannot rest with the court to challenge the satisfaction of president that situations contemplated in that clause exist. So, here and if you see the other observation which was given here. The one hand, the Supreme Court has stated that if the case of the malified exercise of power, or if the satisfaction of the president is based on the wholly extraneous or irrelevant consideration, then definitely in that case they will have the power to go for judicial review, because here the scope of judicial review is somehow being narrowed down or somehow being limited with respect to the provisions of Article 74 clause 2 as well as Article 361 clause 1 of the Constitution. So, under this limited parameters, here the court will examine whether any material exists or not, because here the court cannot altogether substitute its own assessment with respect to the subjective assessment of the executives, because it is the executives who knows the pulse of the peoples, it is the executives who know the exact situation about the prevailing law and order situations and the anything which may be anticipated or contemplated. So, if the on the totality of the circumstances, if the state if the governor has come to conclusions, then there is a possibility of the complete paralysis of the state administrations, or there is a possibility of the complete physical breakdown, or there is a possibility of the grave law and order situation, then definitely in that case here, on the basis of the assessment of the prevailing situations, they can accordingly recommend to the president regarding the imposition of president rule. But here in this case, here the Supreme Court has somehow has given a very broad interpretations to the provisions of Article 356 clause 1, where it is stated that where the government state cannot be carried on in accordance with the provisions of the Constitution. Because what happened in this case is that the after 1977 elections, here the Janata Party came into power. Here at that point of time, the nine state was being ruled by the Congress Party. Home Minister has issued the advisory requesting the Chief Ministers to request the Governor regarding dissolutions of the State Assembly. But in this case, instead of giving this kind of broad interpretations, instead of thinking that here because multi-party system, this possibility cannot be ruled out that the central state can be altogether ruled by the different political parties. So, this is the one of the facts which we have to accept. But here, instead of analyzing the directions which was given, here the Supreme Court has altogether somehow tried to move on the lines which was adopted by the union government, and what the Supreme Court stated that the defeat of the ruling party in the state at the Lok Sabha elections cannot by itself, without anything more, support the inference that the government state cannot be carried on in accordance with the provisions of the Constitution. But according to them, the situations was wholly different. It was not a case of just an ordinary defeat which has been suffered by the ruling party in the state at the elections of Lok Sabha. Here there has been total rout of the candidate which reflected a wall of estrangements and resentment and antipathy in the hearts of the people against the government, which may lead to instability and even the administrations may be paralyzed. Therefore, on the fact of this ground, it was clearly stated that it is the one of the relevant ground under which the president will be justified to impose the president rule. Apart from this, here the Supreme Court has also stated that here the fact that the ruling party in the state has not secured even a single seat in some of the state is also a symptomatic of the complete alienations between the government and its people. It was axiomatic that no government could function efficiently and effectively in accordance with the provisions of the constitutions unless it enjoy the goodwill and support of the people. So, somehow here in the state of Rajasthan case, the Supreme Court has tried to justify the directives which was issued by the then Home Ministers to the Congress ruled state regarding the requesting the respective governor regarding the dissolution of the state assembly and seeking the fresh mandate. Because here in parliamentary system, what is happening that the Lok Sabha elections may be fought on one consideration, state elections may be fought altogether different considerations, and the regional factors becomes more prominent if pertains to the elections to the state legislative assembly. Merely that they have reached to the conclusion that it's only one victory where the Janata Party has secured the massive mandate and the Congress party was not able to secure a single seat, does not mean that here the state government is also have lost the confidence of people with respect to that. So what happened that though the Supreme Court has upheld the dismissals of the state government with respect to these 9 states, but history repeated itself again in year 1980 when this Janata government was subject to the defections, and the Morarji Desai has tendered resignations, and then the president has invited Chaudhary Charan Singh to become the prime minister. He has taken the oath of the prime ministers, but before facing the parliament he also tendered resignations, and then the president dissolved the Lok Sabha in order for the fresh elections. And in that election which was held in the 1980, here the Congress party again came into power with the massive majority in the Lok Sabha, and at that point of time these 9 states was being ruled by the Janata party. So again the government in the center was having the precedent in the state Rajasthan case, so they have also issued the same kind of directions to the respective Janata ruled these 9 states, and they have advised them to request the governor regarding the dissolutions of the state assembly and seeking the fresh mandate of the peoples in view of the complete rot or the complete poor performance by the Janata party in that 1980 Lok Sabha elections. And here, but if you see, if you compare the situations in state Rajasthan and the 1980 case where this 9 Janata ruled state was being dismissed by the Congress, here the situations were altogether different. Here the Supreme Court has altogether given the different kind of interpretations because they were anticipating some more kind of disturbance or the law and order situations or the paralysis of the state administration. But this was not a case with respect to 1980 elections. Still here the Congress government has dismissed all these 9 Janata party ruled state government, and they have decided to invoke the article 356 of the constitution. So after this 1980 judgment, again it was subject to the, and I have already stated in the previous class that this is the one of the provision which was used more than 100 times, and it is the Mrs. Gandhi alone, she has used these provisions for at least 48 times. So again this issue was again considered in details by the Supreme Court in SR Bombay vs Union of India case, and this case was decided by the Supreme Court in 1994, and this case itself is a very peculiar case because in this case Supreme Court has considered not only the dismissals of the state government in Karnataka, but the Supreme Court has also clubbed the various petitions which was filed in the different high court regarding the dismissals of the state government and the invocations of President rule under Article 356 of the Constitution. And here in this case the 9 judgments of the Supreme Court was being constituted, and this case was decided by majority of the 5:4. So in this case the Supreme Court has considered the dissolution of the state government, state of Karnataka in year 1989, state of Meghalaya in 1991, state of Nagaland in 1988, then state of UP in 1992, then state of MP, Himachal Pradesh as well as Rajasthan in 1992 in view of the demolitions of the Babri Masjid on 6 December 1992. So as far this Karnataka case is concerned, here this case is altogether very peculiar. And if you see what happened in the Karnataka case is that after the elections, here the Janata party came into power and SR Mumbai become the chief ministers, and later on there was merger of the Janata party with the Lokdal, and this happened in the month of April. Then in month of May, here the SR Bombay had decided to expand the ministry, and he inducted some of the ministers of the Janata party of Lokdal in the ministry. But here the expansion from ministry has created a dissent among some of the aspirants of the portfolios, and one of the elected members of the state legislative assembly, this is Kalyan Molakde, he expressed the want of confidence in the SR Bombay's leadership, and he submitted a letter to the governors enclosing the support of the 19 legislature which has been defected from the Janata party. So, and when this letter was submitted, and it was submitted on the 17th and 18th of May, the moment this report was submitted along with the list of the 19th legislature who have been defected, this report was sent by the governor to the president on the same date. Then subsequent to that, on the 19th, on 19th of May, here the 9 of legislatures has again expressed their confidence in SR Mumbai case, SR Mumbai's leadership, and they said that their signature has been obtained by the misrepresentations. And the same time, here the state cabinet met on the 19th May, and here the state cabinet has resolves to prove their majority on the floor of the house within a week time. So the date fixed was 27th May, and the same date the chief minister also met with the governor. He apprised him about the decision which was taken the cabinet, and he also expressed the view to prove his majority at the earliest possible time if the situation so demands. So what happened in that case is that here on 20th of May, the governor has sent the 3 reports, and that report, the only ground which was stated by the governor was that the large scale horse trading was going on the state assembly, and it has vitiated the entire atmosphere. Therefore, they have recommended for the imposition of president rule in the state, and on the basis of this simple report, where on there was allegations of the horse trading, without giving chance to the chief minister to prove their majority on the floor of the house, here the president had decided to dismiss the Karnataka government, and they have decided to impose the president rule. And apart from this, I think when the time will permit, then I will take up the case of the other state also. Then I will come out with the guidelines which was given by the Supreme Court in SR Mumbai case, and how this guidelines has become one of the most important safeguards regarding the imposition of president rule under Article 356 of the Constitution.
With this note, thank you, sir. Thank you so very much. And of course, definitely we would be conducting another session for you and would be discussing all what Dr. Rakesh Kumar has said. Till then, take care, goodbye, and keep giving your feedback to us. Thank you, sir.
Thank you, Vitka. Thank you, listeners.